Adjustment of status, frequently asked questions. A lot of time the basics are overlooked, so we wanted to go over the adjustment of status, frequently asked questions. I'm Sam Shihab, and with me,
Brian Burke, both here from Sam Shihab and Associates, based out of the fabulous Columbus, Ohio area. Except for the weather today, Sam. It's started raining out there, unpleasant. But we have a great topic. We're going to hit the adjustment of status FAQs. We're going to do some Q&As right when we return.
all right, so we have an interesting topic today, which is a basic topic. And a lot of times, basic stuff are very important because it's overlooked. We're going to go through frequently asked questions on the topic of adjustment of status. And then in the second half of the hour, take your questions. Hopefully we get through as many of them as we can. Brian, without further delay, let's dive into these FAQs on adjustment of status.
Yeah, I think people with pending adjustments of status out there. And look at that. We have the questions right above us here. And a classic one is, what category does USCIS consider me to be in now? And a little bit of context here. There are people who, file multiple I-45s, and there's people who have multiple I-140s and one I-45 that they've done a transfer underlying basis for.
So what category are you if you filed your adjustment of status? Now, obviously, these are, some of them are advanced frequently asked questions, so we're not talking about 1 + 1 = 2, because obviously it depends.
It's a complex question. So, let's maybe take a hypothetical. If you file your adjustment of status initially in the EB3 category, as so many people did in October 2020, and then you file a transfer underlying basis to an EB2 I-140, I'd say it's reasonable to guess and believe that USCIS considers you to be in the EB2 category, and maybe that when your priority date comes current, they will adjudicate your case in that category. However, as a practical matter, I don't think USCIS really thinks about this issue too much unless your priority date is current. So for people out there, after the massive retrogressions we've seen, I can't say there's a really spectacular answer to that question from USCIS, because I've talked to officers about this at interviews, and they basically don't really seem to care about this until they're ready to make a decision on a particular category. Whether you're current in a particular category is what they really look for.
And therefore, if you believe that you are in a category in which you're current, it doesn't hurt to contact USCIS proactively and not just sit back and wait and assume they're going to do their job.
Yeah, when you're, USCIS, I like to think that they have advanced systems to basically catch when somebody's priority date is current. But historically, for years, we would have to, when somebody's priority date would come current and they had a long pending adjustment of status, we would remind them, send them a letter saying, hey, I'm current.
They do a good job most of the time.
Usually.
But they do drop the ball every now and then.
Yeah. And as things get more back to normal right now, that's when I really kind of advocate more for, advocating for yourself and keeping them in check just a little bit.
Okay, can I spin on that one, Brian?
You certainly may, sir.
What status am I in if I filed my adjustment of status?
What have you been up to since you filed your adjustment of status? Going back to the basics. This is a great basics question. Most people transition to an I-45, especially those in our audience, file a pending I-45 from H-1B status, right? And H-1B status has rules. You work pursuant to the terms of your LCA, and get paid the wage, work for the right employer, and work at the right location. When you walk outside of those rules by, say, using adjustment of status EAD, you leave behind your H-1B status. Not a problem. You're allowed to use your adjustment EAD. They give it to you for a reason. But the bottom line is, if you leave behind your H-1B status and are no longer meeting its requirements, you can still be lawfully present in the United States pursuant to your I-45 and work pursuant to the EAD you get, but you would not be in H-1B status anymore. You would be in a period of stay authorized by the Attorney General pursuant to the fact that you have a pending green card application.
Okay, excellent. Excellent status question if you file your adjustment of status. So by filing your adjustment of status, your status does not change automatically necessarily.
This is true, yeah.
And that's really important for people to know. It does not change automatically necessarily. It depends on what else you do will dictate.
Yeah.
Excellent. Let's take the next one.
Yeah. So moving on.
Why I am being interviewed?
If I had an answer to a 100% answer to this question, I would.
How about foundation first?
Foundation?
Does everyone who filed an adjustment of status get interviewed?
Presently, as of today, this July 24th, 2023, definitely not. Especially for employment-based green cards. Go back 2 years ago or so, they were interviewing, maybe more like 3 at this point, interviewing everybody, including employment-based folks for green cards.
In the context of the family-based petition, almost 100%.
I've been seeing some surprises lately on that. I had, I kid you not, Sam Shihab, a marriage-based petition approved without an interview.
Well, that would be the first in close to 3 decades of practicing law. It is probably a mistake or probably a change in policy. We'll see. But I will revise my 100% to a 99%.
Well, you know, when I was in last week, I was in somewhere in the Midwest at the USCIS field office, and I was hanging out with my clients in the waiting room, waiting for the interview to begin. And I was approached by a USCIS officer, very nice guy. He said, "Hey, could I ask you some questions?" And he asked me generally what my thoughts on X and Y and Z were. And I mentioned, it's unusual. I've seen some approved I-45s without family-based ones without an interview. He said, "Yeah, that sometimes happens. Policy comes from the top, and we just act it out." So
that's pretty amazing.
Yeah,
it's pretty amazing.
Great for people in those categories for sure.
But it's really the exception that the rule,
Sure.
so everybody understands.
Yeah.
I-485 family-based petition gets interviewed. Spouse petition gets interviewed.
Spouse being the most likely to get interviewed for
yeah,
sure.
And clearly other family members also get interviewed because they want to confirm certain things.
Yeah.
But adjustment of status does not get interviewed. But why, if an interview is discretionary, especially in the employment context, why would someone be called for an interview and someone else would not be called for an interview? That's really the question.
Yeah, yeah. And a couple things come to mind. The obvious ones, which usually involve sending an attorney out with them. Criminal history is the first one that comes up for me most. There are certain crimes.
Well, you're hitting it hard. Criminal history is, but I think things are less. I mean, you're correct. But for me, the first thing you get interviewed, well, the most benign scenario in which you get interviewed is because maybe the form was not inconsistent. It created an inconsistency. You check that box here, and then you check that box here, and it could be 100% correct, but it just didn't add up, so you get interviewed.
Isn't that what all interviews are about, though? It's some sort of inconsistency somewhere. It's, we know of something, or, we think your criminal history might be inconsistent with your eligibility for a green card. That's what it's about, though. It's about all these interviews are about resolving some sort of inconsistency.
Like, have you ever worked without authorization and you answered yes by mistake instead of no?
That's a great
one. The things like that, usually that doesn't make sense, and then all of a sudden they're saying, "Wow, let's talk to this guy."
Yeah, that's true. But that sentiment right there, it's wow. Let's talk to this guy is really is
why you get interviewed.
Yeah, we don't know what is that wow though. So you're right, Sam. I came in hard and fast, and one
on the criminal history
possible wow is a criminal history.
100%.
Yeah, tickets, traffic tickets, unless they're serious, drug or alcohol related things, usually aren't going to get you, an interview. But DUIs.
But sometimes traffic ticket, when you said no, I have no criminal history, and you got a traffic ticket that you did not report that should be reported, like I think a penalty of over $500.
Yeah, that's where the threshold is. Yeah.
So that can also get you interviewed.
That is, and this is where if we're in the realm of basic information and public service announcements, here's my one for the day. So on Form I-45, it asks you whether you've been not only convicted of a crime, they ask you've been arrested or cited, like got a citation, like a ticket, or even detained by the police. And that will get you a yes question. I think it's number 25 or 26 on Form I-485. And the answer to those questions is supposed to be yes, if you have.
And 90% of the people get yes on that
Well,
one.
90% of people should say yes, but
Right.
inevitably, if I'm talking to somebody about preparing them for an interview, I'll go, hey, you ever have any speeding tickets, anything like that ever? And the answer is, oh, yeah.
Or charged, by the way. So
Yeah.
you don't even have to be convicted.
Yeah.
So it's extremely broad.
Yeah.
So criminal history for sure. The second one is maintenance of status issues. They feel that you need to clarify your maintenance of status.
Yeah, and when I think about these things, I kind of think I've had some experience with some gotcha maintenance of status questions from the past. I was once with a client who was asked, hey, did you ever go to apply for, I think it was Tri-Valley University. It was one of those questionable universities that was shut down by the government for failing to comply with, student visa standards. And, a surprise question my person hadn't thought of, he got a green card in the end. Or one I had this week was I went to an interview and somebody was asked about, some very specific information about a consulting client they had provided services to about, I think like 3 or 4 years ago at this point, and they were sort of saved it to bring this question up during her green card interview, despite the fact that they could have brought it up years ago in the context of an H-1B or USCIS site visit.
So Tri-Valley question points to another basis for interview, which is suspicion of fraud.
Yeah.
So fraud is not criminal, but if there's a suspicion of fraud, then that can trigger a potential interview.
Yeah, any sort of association of you with some sort of wrongdoing in the immigration context can really get you there.
And also, I will not. I must add the trigger for an interview when it doesn't make any sense. The person needs to be interviewed. It happens.
Yeah.
A lot of people get interviewed. It's like, okay, I don't know why they called you for an interview. Let me go ahead and do it. Yeah. Check. See you later. Bye. That's
the fun in an interview I like to get. Usually when I'm talking to somebody before an interview, it's, hey, there could be a reason, so prepare for that. But I've been there, and they say, well, no, I don't know exactly why you're here, and they never have anything interesting to say, and you go through a very plain Jane, mundane, normal, go through the forms, ask a couple questions kind of interview.
Yep. So the next one is your favorite.
Yes. Yes.
I can tell it's your favorite.
Why? Does this question reek of Brian?
Yes.
Okay.
It has Brian written all over it.
Well, it's a question that I get a whole lot. It's a frequently asked question. Sam, do you not get this question?
Yeah, it's a frequently big time.
So,
what are the chances USCIS are going to find out about me dropping out of college for 1 semester 8 years ago? What are the chances the USCIS is going to find out about my interview at the consulate?
Well, that's where I was going to go. I was going to say DS-160. Yeah, interview at the consulate that went,
really bad, and I did something really bad 12 years ago. So what's your answer to this very frequently asked question?
A resounding, I don't know, but you have to act like they know everything you...
A resounding definite maybe.
Yeah, a resounding definite.
A resounding definite maybe, because we have seen them.
Yeah, we both go to the consulate interview because somebody called us recently for advice. Basically, they went to a green card interview and they said, hey, about your, this is somebody who had been in the United States on H-1B for 10 years, and they said, hey, what about your visa application from when you first came to the United States? I think it was as a student, and you said X on your, maybe it was on a resume or a DS-160.
It was a withdrawn consulate interview.
Yeah.
He withdrew it.
He said, oops, I gave you bad information and took it.
But that was not good enough. And obviously...
Yeah. Well, to be clear, so this person was, was told, hey, I'm going to allow you to withdraw your visa application to the consulate. And eventually he came back to the United States and was allowed to work. And, got a visa, was allowed to stay here and, stay for the next 10 years. And at the time of his green card interview, they bring it up and go, Aha, check this out.
And he did not have counsel with him. And
I feel
it
like
was not very pleasant for him, unfortunately.
Yeah, it's one that upsets us because we feel that somebody got a
If he
bad
had an
rap.
attorney, the outcome would have been completely different. So your chances USCIS will ask about X. I think that my answer to this FAQ is let's talk about X or all the X's, right?
Yeah.
And let's talk about them one at a time and see how we can help you prepare for them.
Yeah. I mean, for me, I usually find that X isn't a problem. You know, X is something. I appreciate you bringing it up to me because I'm talking to you to prepare you for this interview. But if I'm telling you, if you tell USCIS officer about X, that's not a problem for your green card case, and you're supposed to be honest with them anyway. Because if you're not honest and they know about X, it's an issue of you create an issue of fraud or misrepresentation. There you go.
Is there a difference between being honest and being truthful?
I think I get what you're getting at, but I would like you to elaborate on that more.
Okay, so let's assume X is a problem.
Yep.
We find an X and it's a problem.
Yeah.
Okay. Then when that happens, what does the attorney do? And that's really what I'm trying to kind of lead into. Let's assume you talked about a situation where it's a problem. Then we begin from the very beginning. And the very beginning is each question in this form must be answered truthfully. Okay? Truthfully. You have to answer that. The next thing we go through is what information can you provide that you're required to provide, and what information you are not required to provide.
Yeah.
Right?
Yeah.
And we go to the interview armed with the strategy to not guarantee but maximize your opportunity to work around a situation that could be probably potentially problematic.
Yeah.
And we're not talking about the USCIS officer is not your friend, is not your mom, is not your priest, is a USCIS officer. So I think honesty usually is in the realm of family, in the realm of religious honesty with the priest at the church, whatever. That's honesty. We're not here, I mean, we're not saying we're dishonest. What we're saying here is the standard is different. We're trying to be truthful, and we're trying to help people through the law to get their cases through legally and properly.
Yeah, I
mean,
mean,
sometimes there's a fine line.
Yeah, I fully agree. I mean, the questions to those answers, they say the answer to those questions are yes and no. You only have two options, and my frank response to those is, oh, that's a terrible system. I mean, for every one of those questions, for some people there's a long answer to these things, and
yes.
Just because you have a concern doesn't necessarily mean that the answer has to be yes.
Now there will come scenarios in which you tell me X happened, and I'm going to say to you, I don't think I can get you a green card.
Yeah.
There's no question.
Yeah.
There are those.
Yeah.
There are. I've had a person who, for example, committed murder. In the old country, and he said, I went to jail, but nobody knows about it. I can't help this person. I can't help this person.
Yeah.
There's nothing I can do to help this person. So there are X's that are deal breakers, and there are X's in which attorney can probably help you out with, and within the law, legally, and that's what really this FAQ about. And let's take the next one.
Yeah, because we'll never get through any of these if I'm allowed to keep talking anyway. So changes of employment. What happens if I have a change of employment
during my adjustment of status?
During my adjustment of status, yeah.
Okay.
Or if I want to make a change, And for me, my first and foremost answer, people are a little bit scared sometimes to leave behind their original I-140 sponsor and, leave behind their H-1B status sometimes for that matter as well. And people ask, is there going to be any sort of, scrutiny on my case if I take advantage of the portability rules and, say, join somebody pursuant to my EAD? I guess my first half of that answer is, portability rules are there for a reason. The government was nice. They recognized the problem and they said, we don't want you to be tied to your I-140 employer forever, especially when it takes us years potentially to approve your I-45. So the rules are there. They're intended to be used, and don't think they're a trap. Is my first half of that. But I mean, I would say with the tiny asterisks of, I guess you're introducing new factors into your case when you're changing employers. I mean, is your new job in the same or similar occupation, for example?
Excellent point. When do I submit a supplement J?
Yeah.
So when I file my adjustment status, when do I submit supplement J?
Yeah. Well, if you know you're not, I'll take an easy part of it first. If you're filing an I-45 and you're not filing with an I-140, that's one time when you do submit a supplement J. That's just to confirm that the I-140 job is there the same. However, the common question is, portability scenario. When do I submit that supplement J for portability? And I'm curious if the government policy doesn't make it very clear. They say you can submit it in the context of an RFE or at an interview or whenever you want. And my position is always a pretty conservative one of, when your heart's intent changes, that's when you should submit a supplement J. When you decide, hey, this is my new company, this is where I'm going for a green card, that's when you submit the supplement J.
So there has been a lot of discussions recently and opinions in interpreting the USCIS's policy that a supplement J is not required at the time you change employment.
Yeah.
Right?
Yeah.
And there has been a lot of people advising that you really don't have to do it. Just change employment, and because obviously if you're retrogressed forever, just change employment, deal with it later. Okay, nice, fine. That is in fact consistent with
what the USCIS says. Yeah.
What the USCIS says.
Yeah.
Now, that's not what I govern my advice usually is what USCIS says.
Don't take advice from your enemy.
Well, I mean, USCIS is not enemy, but they're not right all the time, and they're not necessarily. They're managing a program.
Yeah.
The green card program. They're not managing your future and your opportunities to stay within the law. That is not where the priority really for them most of the time.
Yeah.
So our advice is different. We think, at least I think, Brian may disagree, that you really have to do it at the time the green card, that you change employment, because your employer may not give it to you when you need it. And that's really important. So when your employer, when you ask your employer to say 8 months later and say, hey, I need my supplement J now, they may say, no, we don't think your job is same or similar job classification.
Yeah.
And then all of a sudden you may discover that you've wasted your time. So we like to do it at the time you change employment because it really lends itself to a little bit more security for you. So that's what I say, but you're thinking deep about something.
I'm looking at the questions we have coming up for the second half of the presentation, if I'm being frank and honest. So
okay. Well, we can definitely go to the next question.
Yes, we'll go to the next of the FAQs.
When can I leave my I-140 employer?
Yeah. So that's when can you take advantage of portability. So we're going back down to the basic level here. And the simple and quick answer is when your I-140 has been approved and your I-45 is pending for at least 180 days. Mm-hmm. However, we must keep in mind that when you do a transfer of underlying basis from one category to another, that resets the 180-day time frame for portability. So that's something you have to think in mind. It's not just when you've been with your I-140 employer, when your I-140 is approved and your I-145 pending more than 180 days. If you submitted the TUB,
absolutely.
Yeah.
Makes a lot of sense. Okay, excellent. So let's jump into the next one, Brian.
Okay.
Any restriction on my I-485 EAD? So your I-485 EAD is the employment authorization document you receive when the adjustment of status is received by USCIS. And it is a document that you receive that is relevant to the 485 and remains valid for as long as the I-485 is valid. And if the I-485 is approved, then the EAD is no longer valid. Or God forbid, if the I-485 is denied, for a very short period thereafter, the EAD is not valid. Now, are there any restriction on your 485 EAD? In general, there's no restriction in your 485 EAD. However, there's a commonsensical things that we have to think about. One of them is, am I going to work in a job that's not related to my green card application? If you're using it to work in a job, let's assume that you have an accounting job and you have a perm labor certification based on an accounting, and then all of a sudden you are doing car mechanics or other things full-time using your EAD. There's no violation of your EAD necessarily, but there could be a problem, obviously, with the green card application.
Well, yeah, I just worry about you veering out on a life road that takes you far away from your intended occupation and finding yourself unable to get back to an offer of a job in the same or similar occupation, I guess is the point, yeah.
However, you could have a part-time job to pursue a hobby or an interest of your own that's kind of not related. So
yeah, I usually say, that EAD, any sort of, most EADs come without limits, but the adjustment EAD, anywhere from, the janitor to the CEO and anybody in between.
Yep.
Yeah.
Excellent. All right, sounds good, Brian. So do we have more?
Yes, we do. They keep
All
on.
right. They keep on
going.
coming. Okay.
Do I submit medical exams if I know mine are expired?
No. Don't waste your money unless.
Well, yeah. See, I have, and obviously, if there's an RFE or interview, you're gonna give them. But I wanted to think about the last question, or rather, when do I submit my 485 and J? As well as when do I submit my medical exams? You can be a little bit, thoughtful and forward-looking on that. For example, if you knew that your case needed you're going to need a supplement J for your case, and your medical exams are expired. That's a scenario where somebody could say, Brian, should I submit these things now? I'd say, well, when's your priority date? Oh, my priority date is like 2 months away. In that scenario, I'd say, well, I don't think it would hurt to basically, try to update your file if you're the sort of person who wants to do that and preempt that I-45 RFE.
Which you may not be able to.
You may not be able to do.
But it can help, yeah.
Anytime you send something to USCIS outside of the context of the original filing RFE response, you're taking a gamble that will actually arrive where it needs to be, of course.
Yeah. Can I transfer my underlying basis if I'm no longer with the I-140 employer? Can I transfer my underlying basis using that I-140 if I no longer with the I-140 employer?
Yeah. For me, reasonable minds may differ on this one, but as I read the USCIS policy, no. To do a transfer of underlying basis to a particular I-140 petition, it requires you to check a box to say that the whole process contemplates the employer that originally sponsored that I-140 supporting that.
Just the thought just the idea that it resets the 180 days clearly confirms that you have to be with the employer.
Yeah. That's my interpretation on that. Yeah.
I agree with you.
Yeah.
How can I engage in self-employment with pending I-485?
Well,
number one, you have to use your EAD.
Yeah.
Okay.
Your H-1B status, for example, is incompatible with starting your own business. Yeah.
Yeah. So you have to do an EAD. You have to use your EAD. The second thing is there's two types of self-employment that you are going to engage with potentially. One that is on the side, you're doing work on your own, and it's not going to carry the green card application. And then the other one is the one that is basically you're transferring to a company that you own for the purpose of continuing the green card application. And that is requires you to set up all kinds of things, including a limited liability company, a payroll, probably I would create an employee manual. I would definitely make sure that I'm not doing administrative stuff. I would be doing the work and have somebody else do the administrative, like maybe a spouse or something.
I think whenever I think of starting my own business, I think of the phrase, if it walks like a duck, talks like a duck, sounds like a duck, it is a duck. Expect there may be some skepticism on your business, porting to your own business, but if you run your business like a business, the government will treat it like a business. The standard of evidence is the preponderance of the evidence, and if you give them what looks like a business to them, you have a reasonable chance of success.
Next one, real quickly, Brian. We're running out of time. What if I lose my job during my adjustment of status application?
Yeah.
Well, clearly, 100% get another job, or self-employment.
Yeah. The conventional wisdom is that, people always say, well, Brian, what if I go like a long stretch? I'd say, basically, if that RFE doesn't come in, if the government's not asking about it, you're probably going to be fine. But my conservative attorney advice says you don't know when that RFE is coming in or that interview is coming in. So get yourself a job, same or similar occupation immediately.
And last but not least, how do I get back on H-1B if I use my EAD during my adjustment of status application? Well, the way to do it is, obviously, there are two ways to do it. The rule is that you must leave the country and re-enter.
Yeah, pursuant to an H-1B visa. And if you still have a valid H-1B visa stamp and a valid H-1B approval, and you just use your EAD card for a year, but your H-1B is still good, as long as your employer is still happy to have you on H-1B, do it. Yeah.
And then in the limited circumstances, if you're working for the same employer and have not taken a job outside and you use your EAD for a short period of time, potentially there is the ability to extend it.
Yeah, if you come back from travel abroad, they will consider your H-1B to be valid and allow you to extend it. But
And that is our frequently asked questions on adjustment of status. Hopefully they were helpful, and when we come back, we're going to be answering your questions. All right, so this is the time when we answer your questions, and we're going to be jumping on your questions and taking them one at a time. Just remember, we answer questions on the fly. Please do not rely on what we answer to make a decision on your case, because we just do not know enough about your case and your background to advise you at a level where you can make a decision. And there's not an attorney-client relationship established because we answer this question. Without further delay, let's take Sky Limit.
Sky Limit with a very relevant question. Hi, Sam and Brian. During last week's presentation, you answered to one of our questions about EB2 Priority Date portability to EB5. You answered that it's possible to use EB2 Priority Date to EB5. And he kindly follows up explaining it's not possible. And
correct,
Sky Limit's entirely right on this. I have no doubt that one of us said that. I wonder if it was me, but I can't fathom why we would bring it up, because the bottom line is EB5 is current for across the board for everybody aside from the unreserved categories for India and China. So
doesn't matter. So thank you, Sky Limit. You cannot port your priority date. You can only do it between the three categories. Yeah. You cannot. You cannot port from EB2 to EB5, and if you're born in India, you shouldn't worry about it, because not every category is current, but there is enough available visa that is current today that porting to an EB5 is not required. Yeah. But thank you so much for bringing that to our attention, Sky Limit. We always appreciate your contribution. Yeah. Blacksmith 2.
A question outside the usual scope, but one I like.
My brother, U.S. citizen planning, my brother, who is a U.S. citizen, planning to apply for, what? I'm confused.
My brother, a U.S. citizen, is planning to apply for a green card for my mother, but she doesn't have a birth certificate.
Oh, I see.
What are her options? So,
easy. That's an easy one. Right.
Okay, all right. So depends upon whether or not you don't have a birth certificate, really kind of whether it matters, depends upon your country of origin. I know a lot of our clients are born in India, and thereby this person's mother might be, so I'm going to use the example of India. If you read the Department of State's, what they call the reciprocity tables, I believe they say, I think it's a date before a certain date in 1974, maybe it's 1970, they say, hey, we understand that before that date, we don't expect Indians to have birth certificates necessarily. And however, you may still get an RFE from USCIS saying, hey, where's the birth certificate? So my sort of ironclad way to try to address it is, one, attempt to register the birth late. If you can try to register somebody's birth as long as they're still alive, and probably even after it, I would imagine. And if you attempt to register their birth, the government officer has two options. One is to say, sure, here's a birth certificate. Two, they have the option to say, I can't do that, and issue a certificate of non-availability saying, hey, we tried, we can't register this for whatever reason, we don't have records of it, or we're just unwilling to do it. I can't give a birth certificate for this person. And in either of those circumstances, being a late birth certificate or a non-available one, the recommendation is to get secondary evidence. Secondary evidence would be other evidence of this person's birth. The older the better, as always. That might include religious records, school records, government records, medical records that would sort of show the same information that appears on a birth certificate, like your parents' names, your date of birth, your place of birth. There you go. Always on top of that, useful are affidavits, sworn statements from people who are, familiar with the details of the person's birth. It should be somebody who was born at the, before the person that was born, and somebody arguably old enough to remember it. So, picks ideally somebody over the age of 18 at the time when the mother was born. If your mother's particularly old, that just may not be possible, and you go without affidavits. That's my always sort of ironclad way to address a non-available birth certificate. As a practical matter, for the scenario of India, if the Department of State reciprocity table says a birth certificate is not available, USCIS is generally pretty happy to understand that fact.
Yeah. Well, birth certificate issues, it's an excellent summary, Brian, thank you. Birth certificate issues are fun and requires a lot of patience because not only India, all over the world, there are issues. Sometimes people are born to one country, and then now it's a different country.
Yeah. Ooh, those are fun.
Sometimes people are born.
I'm touching wood. I don't want to get one of those. Those are painful sometimes.
Sometimes people are born in a place that it does not belong to any country, and then trying to define the location and the history and look. Sometimes you even need to look at archive papers.
No, I remember dealing with Libyan ones a couple years ago, and
that's because of the war.
Yeah, going with I remember coming to somebody for translations of Arabic documents to figure out what the heck any of these things mean and what version of the country it was from.
The fun one that I remember is a person born in the Palestinian territory, which was Jordan at one time. It was Israel another time, and it became a Palestinian territory at a third time, and trying to chase between. Israel says, no, it's not our country, we don't have any record anymore. Jordan says, no, we don't have any, it used to be a territory only. So, but you put the facts together, you piece it up as much as you can, and you're persistent, you do the best you can. Most cases get approved. If your mom wants to come here on a green card, hire a lawyer, it's easy, it can get done.
Yeah.
All right. So, and Kita Tulani. Hello, Sam. My EB3 rest of the world priority date is 15th of July 2022. Do you expect my priority date to be current for October visa bulletin? Well, let's look at it.
So EB3, rest of the world. Okay, there it is. EB3 final action dates for August 2023. They are in May of 2020, but I am going to look at the dates for filing instead. And I see EB3 is at 1st of May 2023 for dates of filing. And that's a July 2022 EB3 rest of the world. Wait a minute.
Yeah.
And they're at July, they're at May 2020 for EB3 right now. I'm inclined to
believe that there is a reasonable chance.
Yeah. The dates for filing are supposed to be a forward-looking version. Historically, they've said, 8 to 12 months, something along those lines. And the dates for filing suggests that, there you go. I can't help but note if somebody is trying to file an I45 based upon the rest of the world EB3 and that priority date, if they haven't filed that I45 yet, and as long as these dates for filing hold, the USCIS often goes by dates for filing in the month of October, meaning there's a good chance that you would be able to actually file that I-45 if you haven't. But there's a follow-up that makes my point irrelevant.
My I-45 was filed in April 23 and is currently pending. So she's looking for not necessarily the filing, she's looking for approval.
When is it going to be
Okay,
approved?
so obviously you need to make sure that the final action date is current, not the dates for filing is current. And I would say there's a reasonable chance that the final action date will be current by October.
I am inclined to believe that.
All right, so Brian, take that one.
From Anand R1212. Hi, I have an approved I-140 and doing consular processing since I'm not in the U.S. Oh, I'm sorry that you have to do consular processing. It takes so long sometimes.
Yes.
Is there an EAD / AP equivalent for consular processing applicants after I become documentarily qualified by the NBC that allow me to enter and work? Ooh, that's a I think there should exist something like that, but practically speaking, no. I'm not quite sure about.
So when they enter the United States, they get stamped with an I-551 stamp on the passport.
Yeah.
And the I-551 stamp is work authorization.
But I think the question that Anand is asking is there something that will, hey, I'm documentarily qualified and I'm waiting for an interview. Is there anything I can do right now?
He's in the U.S.
He's not in the U.S. He's outside of the U.S.
So why would he care?
Why would the consulate care?
No, well, what is?
So the scenario, as I understand it, is this. Okay, the consulate has said you're documentarily qualified, but as some of you guys are aware, it can take a long time for a U.S. consulate to get you from documentarily qualified to interview.
Yeah.
And is there something that allows me to come to the United States and work in the meantime? And my answer for that one is no.
So there is a parole rules, and I'm assuming he is in the EB2 or EB3 category, and there is no opportunity to take advantage of any of the flexibility that they've created for investors.
Yeah, okay. Yeah, that one.
Yeah, so that's the only one that's available, but for you, no, there is not one, but there should be one.
Well, when I think about this scenario, I think of somebody, I mean, maybe this person has never been to the U.S. before, but I think if you have an approved H-1B in the past, you may be eligible for additional H-1B time based upon an approved I-140. However, the rules for that are, when your priority date is current, are a little bit complicated. So, you know.
But it's worth looking into.
That's something I would look into if you're trying to work. Yeah.
Yes. All right. Suresh M. Per USCIS, there's 350,000 approved I-140s in EB2 India pending for visa allocation. Are there I-140s applied until March of 2023? How many of these were already applied for 485 and pending for green card allocation? Well, great discussion item.
Yeah.
We have the number, the 350,000 approved I-140 EB2 India.
Was that the number of the I-140s waiting for the spreadsheet? Do we still have it up here?
So do you have that spreadsheet?
Yeah. Yep. Here it is. Yeah. The rest of the EB2. The EB2 India, yep, 358,000 and some change. Okay, pending the visa allocation. Are those I-140s applied till March 2023? So the dates, those are as of March 2023. Yes, so that number was that. How many of these were already applied for I-45 and pending for green card allocation? That is something that would be a different report from USCIS, and it would be a report of their I-485 inventory. But my problem is the last time I looked into such a report, it doesn't report the category that the pending I-45s are in. The only time I think we saw that information was maybe about the end of, 2021, or when there were court cases where USCIS was releasing those numbers.
And that's it.
Yeah,
and these numbers are too old now and completely irrelevant.
I forget them.
We don't have access, but we'll make note. Maybe we'll look into that.
I'm not sure there's a way to extrapolate that based upon the data that USCIS puts out, unfortunately.
All right. Praveen R. My EB2 priority date is November 2012, and I completed interview in August 2022. FP is June. Okay, is there any follow-up question?
What is FP in June 2020?
Well, let's see if there's any follow-up.
Yeah. And the bad luck is after my interview went well, after a week the dates were frozen, allocation of visa numbers were stopped, and the dates were retrogressed for the next month. Oh.
Yes.
So can I expect my priority date to be current in the next fiscal year?
For 2012, for crying out loud, it would be very sad if 2012 cannot become current again, but it may not
November
be.
2012? What was this, when
EB2, he said, right?
Yeah, November 2012, EB2, rights for filing, final action. EB2 India is in January 2011.
Yeah.
But where are their dates? I mean, Sam, I'm going to look at the dates for filing. The dates.
May 2012.
Yeah. Let's bring up an interesting point. The department.
November, so it will not reach to that.
That's if this department. If we trust the dates for filing to be a projection of what the Department of State thinks is coming in the near future, the EB2 India says 1st of May 2012, and that is well before November 2012. One point of.
And therefore, just to conclude, therefore we don't think that it will be ready in October. In October.
Future, yeah.
Yes.
Yeah.
Unfortunately. All right.
Yeah.
Talk to SAN. Is it illegal for H-1B holder to invest in publicly traded cannabis stocks? If so, what should someone do as he has already invested in cannabis stocks in 2021? So we kind of had this discussion last week and that question last week, and we never followed through on it.
Yeah.
Because we honestly thought that it was an extremely interesting question. But we never did follow through to really give a good answer. Talk to SAN. I think it needs to be looked into a little closer before we can answer.
Yeah, I mean, fundamentally, I'm not involved in any sort of drugs, and there's like I'm working in the garden, cutting marijuana stems. That's kind of the scale we're at here. And Talk to SAN is talking about an investment in a publicly traded company that's listed on a stock exchange. And this is the sort of question where I'm not sure that there's an easy answer for this found from USCIS. For the record, it's the sort of thing where I expect might come up in a court case. Where what it would take for me to find a definitive answer to that, Sam, would be somebody out there having been denied a green card on that front, and then USCIS issuing a formal decision when somebody tries to appeal it.
Yes, I honestly think that this question deserves a little bit of a careful review before we can give an answer, because we can probably give you our common sense, but not our legal answer.
Yeah.
Because there has to be some guidance somewhere, either a case law or so. If
I'm not sure there's going to be case law
or an opinion or informal opinion or
perhaps,
some kind of a.
It's worth looking into whether or not that exists, because. Again, it's in terms of like connection to the industry, it's pretty far out. But
so it's interesting question, obviously, and an important one. We've never encountered that specific question. Honestly, we've answered a lot. We've dealt with a lot of things, but not that question. And I think it deserves to be looked into. So, Talk to SAN. We're going to give you an answer by next week.
All right.
All right. So moving on to the next one here, I have BN, I think it is Bagya. But
Bagya, yeah.
Why hasn't USCIS still not taken any action on companies that cheated on fiscal year 2024 H-1B lottery? Thousands of innocent victims have no option but to leave the country due to this issue. He must have a continuation, maybe? No. So. Angry face, I guess. So, because USCIS is a lot of talk and no action, that's what you're dealing with the government. And also, maybe the more polite answer or less obnoxious answer is that, unfortunately, the wheel of justice is very slow in this country. Brian.
Well, my one answer would be, we've taken consultations from people who have worked for companies who have been accused of this thing, and they've showed us RFEs from these companies. So that's USCIS going after that company. And the one I can think of, oh boy, it really sounded like USCIS was really going to go after this company pretty well. But there's another. I mean, fundamentally, I think this is going to go through the Department of Justice, who would it's a criminal matter as well. And I kind of agree with Bhagya here in that we're sitting around here every now and again and saying, when are we going to see these criminal complaints in court against these people, if it is in fact a crime? I don't know.
Well, I think also in reality there is a big gap between what people are expecting USCIS will do and what USCIS will ultimately do. And here's what USCIS will ultimately do. USCIS is not going to go after everybody. They don't have the time, they don't have the resources, nor the patience to do that. What they're going to do is they're going to go after 4 or 5 companies, really bad guys, and they are going to basically throw the book at them. They're going to probably try to criminally charge them, probably try to put a couple of guys in jail, and trying to scare everybody with the example of these guys. That's the only way the government can manage 400,000 duplication. They have absolutely no ability to figure this out.
That's a massive undertaking. You could, if you wanted to.
Impossible.
Even to figure it all out. I mean, those court cases themselves. I mean, I'm taking it sort of at face value for the purpose of this conversation that those people have, committed some sort of fraud or crime. But their policies, USCIS's policies, are a little bit wishy-washy, wavy gravy on those, and I would be very intrigued to read, the criminal complaint to see what they say the crime is, and then I would love to read what their response is, from these companies, because I would question.
So you're adding one more layer of complexity, is that they have also challenging legal standards that the defense can use to say, we haven't broken the law.
You just pulled a crime out of your ears.
You're just creating some system, ridiculous system. Unfortunately, the losers, there are 2 losers here: the H-1B applicant and this country. Unfortunately, USCIS cannot manage this mess that they get themselves into, and that's my answer. Let's take the next one.
From Ron, are we allowed to use I45 EAD for secondary employment while working on H-1B for green card sponsored employer who filed PERM, I-140, and I-45? If not, in what way is the EAD useful for? So I think this goes back to one of the frequently asked questions that's you and I answered earlier. To be clear, using that green card EAD is incompatible with H-1B status. If you're employed on H-1B status, you are working for as many employers as USCIS has approved, because multiple employers is possible while on H-1B status, if you file an H-1B petition that says multiple employers. But when you get that green card EAD, it's an entirely different thing, separate from your H-1B approval, separate from your H-1B work. You're allowed to use that EAD, and it is useful. It is useful because you can use that EAD to work for anybody in the United States, including your existing green card sponsor employer. I guess I would say it is entirely useful, but it is not used in the context of H-1B status. By using that, it is technical, and there's not an alarm that goes off when it happens. But when using that EAD, you leave behind the 4 corners of what is allowed on H-1B status.
Good answer. Karthik.
Do we need to submit Supplement J for EB1A if we are changing employer while AOS is pending?
Good question.
Yeah.
The answer is no, you don't. However, as long as the EB1A is not built around the employment with the first job.
So EB1A, it's the
extraordinary ability.
We're calling, and doesn't require that you have a sponsoring employer. Is
Correct.
The bottom line. So that's why you come to that answer. And that's
yes.
If I had a weird look at my face, I was trying to remember.
You're thinking,
which one is EB1A?
Yeah, I don't know. It's okay.
Yeah.
Well, that's why we're here together. Hari Guru. Hi Sam, Brian. I am really sorry during last week. You don't have to apologize. I entered my priority date wrong and caused some confusion. No problem. Looks like we also told people that EB2 can transfer to EB5. Potentially, I don't know. So we all can make mistakes. That's why don't make decisions here on your case or your life because we're just exchanging information.
Yeah.
But happy that you're calling and asking us again. Priority date is January 2013, EB3 India. Filed adjustment status in October 2020. Got EAD and advanced parole in 2024.
And here's part 2.
All right. Work situation is a little fluid. My employer might be asking us to work from India due to budget. In case if I didn't find a job, might relocate to India for now. In this case, what happens to adjustment of status? Okay. Well, two things here I see in my mind that kind of spark. You know, number one, I worry about working to India due to budget, meaning that there's no opportunity in the U.S. that's available. Potentially. But that opportunity should be at the time of the green card approval, not necessarily now.
Yeah.
And it really should be when USCIS asks. So they can issue an RFE and you have to prove the opportunity at that time.
Yeah.
If your work in India is temporary and it is related to the employer's need, not to the employer's financial problem, but to the employer's need, then I think the adjustment status is valid for as long as you're renewing your advanced parole. And
I mean, it gets kind of complicated to renew your advanced parole.
you have to come to the U.S.
Yeah,
You have to come to the U.S. And also that there is an offer of employment in the U.S. with this employer, and this employer is financially sound. Because if the employer is not financially sound, there could be a problem. They can reopen financial ability anytime. Brian mentioned something to you last week, and Brian said, have you considered porting to a new employer?
Yeah, that's clearly less. I like that guy last week because that's immediately what I'm going to. Because as Sam's talking, I'm scrolling up here and reading the facts. You know, looks like the I-140 is approved. The adjustment of status has been pending since October 2020. It would look to me like somebody who's eligible for portability. Now, it sounds like Hari Guru is loyal to his employer, and that's an admirable quality. But you know, it would seem reasonable to believe that he might be eligible for portability, and that's.
But if it's 5-6 months, yes. But extended period, 2-3 years, I would be concerned.
Yeah. I mean.
100%, I would be concerned. Yes. There's no bright line. One officer can think that this is like no big deal. Another officer that is going to think it's a huge deal. But in my opinion, you cross 7 to 8 months outside the U.S.
Yeah.
You're beyond my comfort zone.
People ask me, is it going to be a problem if I leave? And I say, for a long time, I say, let's not find out. You know?
Yeah, that's a good question.
Yeah, I don't want my clients testing the limits of immigration.
Of that specific officer you're going to be interviewing with.
Yeah.
All right, Sam Fax, I got a question for us. Hello, EAD advanced parole is up for renewal, expire in January of 2024. Passport is up for renewal on June of 2024. Can I apply for EAD renewal with current passport details and apply for passport extension immediately? Will it cause an issue? It will not cause an issue, in my opinion.
Incredibly unlikely that in my book that it will cause an issue. Basically, you know, USCIS really doesn't seem to care as long as you have a valid passport.
It's different than entry into the U.S. and how much time they give you.
Yeah.
All right, sounds good. Next one here from
From BN Bagya.
Bagya.
So,
do you guys think second round H-1B lottery for 2024 might happen sometime this week,
well,
Brian?
You know, based upon Bagya's earlier question, I'm pretty sure this is something that Bagya asked last week as well. I guess this is somebody who has not been, you know, selected in the lottery, is the bottom line. And I guess we're getting closer to the point where we might see a
second round.
I can't remember the last time we saw it in prior years, but again, it was in August.
Yeah.
And
how about we think within a week or two?
Hey, just because I did something in prior years doesn't necessarily. And plus, it may not happen at all. And I guess I would say temper expectations because I have no clue how many people were backed off. I know historically the second rounds were much smaller, but it just really, I'll cross my fingers for you.
Verma, Does EB2 National Interest Waiver follow the same priority date as mentioned for EB2 India in Visa Bulletin?
Yeah.
Yes. Heard from somebody that National Interest Waiver is always current or gets processed very quickly like EB1. Is that accurate?
No, I mean, the last national interest waiver case that we filed came back very quickly, in my opinion, in terms of processed by USCIS, but in terms of actually getting the I-140 approved. But unfortunately, yeah, the line is a bit, is still the same old line.
Shiva Varma, good evening. I'm planning to return on EB2 advanced parole, but I have two 485s, both EB2 and EB3. Will I be locked under EB2, or do I have H-1B with same employer and do I need to use automatic revalidation for H-1B? 25 questions.
Yeah, that's dense.
So at the 7 o'clock hour, whatever advanced parole you use will not lock you in that advanced parole.
Yeah.
That's number one.
Yeah.
In terms of coming back, if you come back on advanced parole and join the same employer, potentially you can extend your H-1B by filing an H-1B pursuant to the 25-year-old memorandum. With regard to automatic revalidation of H-1B, so if you've left to a contiguous territory and came back and have a prior H-1B stamp and have a I-797 that's valid, you could utilize that as a possibility, but somebody has to help you figure out what's really the best scenario for you, but holistically looking at your case. Because we're just kind of dissecting, answering question here, not enough to kind of wrap our hand around your case. So you really need maybe help to figure out what's the best option for you. Yeah. Brian, is there anything left to answer here?
I think, we'll take this last one here. And,
we'll take this last one. Take it, Brian.
So from Prasad, 2 weeks ago, I used my AP while coming back to the USA. What would be my status? My H-1B is valid till November 2023. Am I on EAD or H-1B status? So if you used, first of all, check your I-94. If anybody doesn't do it, check your I-94 when you are admitted to the United States, because USCIS, or excuse me, the Customs and Border Protection is supposed to update it every time you enter the country. And that is going to be what I, of course, defer to. If you're telling me you entered on advanced parole, my answer is going to be you are a parolee. And if you would like to get on H-1B, back on H-1B status, and you're returning to the same employer, I'd say there's a reasonable chance you're going to be able to do that if you file an H-1B extension before your current H-1B expires, and maybe they'll even take it after the fact. Yeah.
Yep. With that, we conclude today's session. I hope it was helpful to you guys. Have a fantastic rest of the week, and we will see you hopefully next week, Monday at 6 o'clock.